Hi Rahul,
Yes, sir. Hello.
how are you?
Well, good. How are you, sir?
All good.
Participants are waiting, so we'll wait. There's 10 minutes left. You can do your work. You can continue your work, and we can start on the time.
Yeah.
No problem, sir. Hi,
So
Rahul. Yes, sir. Hello. How are you?
Good evening, anyone. Am I audible? Good evening, anyone. Am I audible?
Yes, sir.
Yes, sir.
A small announcement. There's been some problem with the email ID. So this announcement is for the members who have registered via the registration link. The problem is like
Yes, sir.
there are some email IDs which have been sent to us which are wrong, and so the emails which are being sent with email IDs are bouncing back. There's been some problem with the email ID. So this announcement is for the members who have registered in the registration link. The problem is like
Yes, sir.
there are some email IDs which have been sent to us which are wrong, and so the emails which are bouncing email IDs are bouncing back. There's been some problem with the email ID. This announcement is for the members who have registered in the registration link.
Hello everyone, it's a request before we start the session. Please switch off your audio and video so that we have better connectivity and bandwidth, and as soon as possible, Sir is with us and we can start the session. So please switch off your audios and videos. If not, we have to remove you from the Zoom meeting. Please, it is a request, please cooperate. Before we start the session, there's a simple announcement. There are a lot of queries with respect to certificates and attendance. So the organizers have decided that those members who had registered via registration link for the program prior to registration deadline will be given certificates. Many participants have given invalid email IDs, due to which emails have been bouncing back. It has become impossible to check which ID is valid and which is not. I request all those participants who had filled out the Google form to register themselves for the course to please drop in an email to lexadr.certificates@gmail.com. The email ID is lexadr.certificates@gmail.com. We shall then be able to email you the e-certificate. We apologize for the inconvenience and thank you for your cooperation.
Should we start now?
Yes, sir. Everyone is here and it is the time. We can start, sir.
I hope everybody has joined in, and uh, good evening, everybody. I once again thank all of you for joining this talk, being part of this talk, and joining in such a good number. Uh, yesterday, yesterday we talked about arbitration agreement primarily. What is the significance of arbitration agreement, how to write this, how not to write this, how does it affect your arbitration, and so on. Today, I have an assignment for all of you. An assignment is that try writing arbitration agreement, one for domestic arbitration, another for international commercial arbitration. Write for different situations. Give a try to this. This will be a good exercise to do and test your writing, whether you have passed yourself or not. For international arbitration, you can compare your drafting of arbitration agreement with model arbitration agreements of different arbitral institutions. So that is one assignment I have for all of you. So after today's talk, you can attempt for that. So that was one assignment. Today we are going to discuss and talk about interim major orders by courts, and we'll touch upon slightly on the such parts of the arbitral tribunal. Why we need to really talk about this? Reason is that such interim measures are very important in many circumstances. You have an arbitration agreement, you intend to invoke your arbitration agreement, you want to commence your arbitration, but you may come across a situation where you need some immediate interim protection so that arbitration does not get frustrated, or the award which ultimately you obtain does not remain only a piece of paper. So this is very important aspect in many arbitration disputes. In fact, during this lockdown, I had occasion to approach Delhi High Court for an interim protection with respect to one foreign seated arbitration. So this is something very important. Considering the importance and relevance of this particular aspect of arbitration, I thought of talking about this in some detail. What is the purpose of any such interim measures which you obtain and seek to obtain from courts? Purpose is to ensure that once award is rendered, the final relief still remains possible and award can still be enforceable. So this is essentially the purpose of such interim measures of protection which you get. If you look at globally, in many jurisdictions, till not very long ago, such reliefs were not available through courts. The understanding was that if you have opted for arbitration, you should avail your remedies in that process of arbitration, and you cannot go to courts. There were jurisdictions which used to hold a position that if you go to court, despite there being arbitration agreement, in that event, you will be deemed to have waived your right to arbitrate. So, in certain jurisdictions, if a party used to approach court for certain interim relief, we are talking about interim reliefs, interim protections, interim measures. Now, not the final relief. Final relief, if you go to court, then you initiate an action, you file a suit. So that is not what we are talking about today. What we are talking about is some interim measures, interim protection from the court. Now, however, modern law has brought some sense in this whole debate, and modern law Article 9 says that it is not incompatible. Modern law means ancestral modern law. Modern law says it is not incompatible for the courts to pass orders for interim measures despite of there being an arbitration agreement between the parties. So notwithstanding existence of an arbitration agreement, courts can still pass appropriate interim orders in your favor or in favor of a party. Now, so that is the model law. Now, modern law really does not go in details of what all kinds of orders, interim measures, orders can be passed. However, at the same time, modern law, like your Indian Section 9 of Arbitration and Conciliation Act, does not restrict the nature of relief which can be granted by the court by way of an interim measure. Therefore, modern law and our Arbitration and Conciliation Act recognizes that even if you go to court, despite there being arbitration agreement between the parties, you do not waive your right to arbitration. So there is no waiver of arbitration as a process, or there is no abandonment of the right or the process of arbitration. If you see your Arbitration and Conciliation Act, or if you see similar provisions in different other jurisdictions, the types of interim measures of protection are essentially restraint from removing assets. So one party may be restrained from removing its assets, or freezing orders. So that is one thing. Another thing could be, another order which generally parties seek for is restraint against a party from removing the evidence. So you should not remove the evidence which may be useful for the determination of the dispute. To that effect, court can pass an order, or court can pass an order whereby it can restrain you from doing an act which is likely to cause any imminent harm or prejudice to the arbitral process itself. In fact, this remedy of interim measure also includes anti-suit injunction. So sometimes what happens, and this is very common, let us assume that you have an arbitration agreement and one of the parties, instead of going to arbitration, goes to a foreign court or the court of his jurisdiction, initiates an action by filing of a suit. What do? So you seek anti-suit injunction. So that is also a remedy. In fact, anti-suit injunction can be passed even by the arbitral tribunals. Now, if you want to obtain an order for freezing of assets, in fact, best thing to do is first try to locate the assets. Suppose your apprehension is that if I obtain an award, and when I go to execute my award, enforce my award, by that time, the other side would have disposed of all its assets against whom I could have enforced my award. Suppose other side has got some huge property in one jurisdiction, and you are hoping that tomorrow, if I succeed in arbitration, I can get that property attached, I can get that property sold, and I can realize the awarded sum. But if your apprehension is that other side is intending to dispose of that property, in that event, you can go to the court within whose jurisdiction that property is lying, and you can obtain an order. And if court finds favor with you, court, if you are able to establish all the ingredients for passing of such an order, then court will restrain the other side from disposing of its asset. Now, that is one thing. Sometimes one may have assets in different jurisdictions. You can go to different jurisdictions even before commencement of the arbitration proceeding. In India, you have in provisions in CPC, and before I move ahead, I must tell you, when you go to court for seeking such protections, getting orders for interim measures of protection, here you need to know civil procedure code. Your advocacy skills will help you in such proceedings, because these proceedings are happening in court of law, and where CPC applies for the purposes of decision of this particular proceeding. So that is why it is said that for arbitration lawyer, it is also important that he knows the court procedures, CPC, so that it helps them in obtaining such relief. What happens is, when you go to court will obviously, what you need to establish in court in order to obtain such relief is, first of all, the triple test for obtaining any injunctive order in the court proceeding: prima facie case, balance of convenience, irreparable injury or harm. Obviously, you may have a situation where in the contract you have negative covenants of which you are seeking enforcement, in that event, you have judgments like Gujarat bottling, which has got paragraph 42, where I still remember because in my this section 9 proceeding, which I argued very recently during lockdown, I had read over to the Honorable Judge this particular paragraph. It says that if you have got a negative covenant of which you are seeking enforcement, in that event, you need not establish prima facie case and irreparable harm, because court is simply asking the other side to not do what that party had itself agreed not to do. What is negative covenant? Negative covenant is a covenant or a clause in a contract which says that a party will not do A, B, C, D, E. So the moment it is said that party will not do A, B, C, D, E, and you go to court, you say, ask him to not do A, B, C, D, E. Then court says, I need not really bother myself with prima facie case and the irreparable harm argument. Though that does not mean that you should not have any case or you should not bring on record some case in your favor. Now, coming back to section 9 proceeding or provisions similar to this proceeding, whenever, so under section 9 of Arbitration and Conciliation Act, you can go to court at 3 stages. One is before constitution of the arbitration tribunal, means arbitration tribunal has not yet been constituted. So either you have not appointed your arbitrator or other side not appointed their arbitrator, or both sides have nominated their arbitrator, but the chairman has not yet been appointed. In other words, tribunal is not yet constituted. If tribunal is not yet constituted, you can surely go to court under section 9 in India and request the court for passing such an order. So that is one stage. Another stage could be that arbitration proceeding has already commenced. Arbitration proceeding has already commenced, it is going on, but you want a relief which either the arbitral tribunal cannot pass, or you want a relief where, let us take a situation. I have done it in recent past, one case where I went to court and said, I want a relief against the party who is the signatory to an arbitration agreement, but that order will not be sufficient unless there is an order also against a third party who is not a party to the arbitration agreement. In other words, I cannot take that party to arbitration proceeding, that third party who is not a signatory to the arbitration agreement cannot be party to the arbitration agreement, but section 9 court while exercising its jurisdiction under section 9 of the Arbitration and Conciliation Act can pass order even against the third party. Let us take a very typical example, a very common example, that you have a construction contract with a party A, and that party A is seeking to encash the bank guarantee, and you also want to implead bank which had issued the bank guarantee. In that case, court can even restrain the banker which is the issuing bank of that particular bank guarantee. So that remedy is available against third parties also. So there are multiple judgments to this effect. Now, another stage which gives you again a right to go to court is, but section 9 as it is today in our Arbitration and Conciliation Act says you will go to court during pendency of the arbitration agreement only if the remedy provided under section 17 is not efficacious. So if you cannot get a particular relief before the arbitration tribunal, only then you will go to court during currency of the arbitration. In fact, this is the latest amendment in Arbitration and Conciliation Act. This particular provision was not there earlier. Earlier, there was no such provision. In other words, earlier people used to say that arbitral tribunals and the courts are having concurrent jurisdiction. Courts still have concurrent jurisdiction, but in a very, very limited circumstances. Now, another stage when you can approach the court for seeking interim protection or interim measures is after passing of the order, after passing of the award. That means proceeding has run its life, award has already been passed, still you can go to the court for seeking some interim order. However, there is a caveat here, and caveat is you have to approach the court before you have sought enforcement of the award, before you have got initiated an execution proceeding in the court for enforcement of your award. Because once you have gone for enforcement, that what all orders you are seeking from court as an interim measure, that all will be available to you in the execution proceeding. So before you have got initiated your proceeding under section 36 of Arbitration and Conciliation Act, which is for enforcement of the award, you can always go to court. It means from the day when you have signed your arbitration agreement till the time you have got enforced your award, you can go to court and obtain such a relief. Now, these were the three stages. Nikhil Prakash asked a question, can interim measures be obtained before constitution of the tribunal? This is what I said. Yes, you can obtain interim measure of protection before constitution of the tribunal. Answer is yes. Now, another very important aspect is that under certain arbitration institutions, not all, but under the rules of all popular arbitration institutions. Before I talk about this particular aspect, which I'm going to touch upon now, let me just, for the sake of refreshing everybody's memory, I'll give you 5-6 names which are popular arbitration centers in world. The most popular one, which I mentioned yesterday also, is ICC Paris. Second would be London Court of International Arbitration. I'm not naming them in any particular priority.
Please note that the following.
Somebody said something. So London Court of International Arbitration, LCIA, Singapore International Arbitration Center, SIAC, Hong Kong International Arbitration Center, HKIAC, America, you have AAA, American Arbitration Association, that is for domestic arbitration, and ICDR, this is their international arbitration. For international arbitration, in America, you have ICDR, you have Swiss Arbitration Association, you have Mauritius International Arbitration Center. Every country has got their arbitration centers, but these are some of the arbitration centers. So we should keep this in mind. Now, when you have entered into any international arbitration, now somebody is asking some question about renegotiation of contract during COVID. Renegotiation is always possible, even if you have commenced the arbitration proceeding, and it's always a welcome step. Now, another thing is, under the rules of various arbitration institutions, you have provision for something called emergency arbitration. Emergency arbitration provisions entitles a party to approach the particular arbitration institution, requesting that particular institution to constitute one arbitration tribunal that obviously is always of a sole arbitrator, so that he can obtain interim measure of protection in the shortest possible time. And under these institutional rules, they will appoint the emergency arbitrator generally within 2 days of your request. The day you send your request, within 2 days, by and large, they will appoint a sole arbitrator as an emergency arbitrator. And within 15 days of his appointment, emergency arbitrator will be required to pass emergency arbitrator decision. So, and the order passed by emergency arbitrator will remain valid till the time the main arbitration tribunal is appointed. Now, there are, again, as per those rules, the emergency arbitrator cannot become the member of the main arbitration tribunal, which will be constituted at later stage. So, under the rules of institutions itself, you can obtain relief within the shortest possible time, and that is a very good idea to go for. Now, sometimes, in fact, during this lockdown, I had said yesterday also that I had approached for an emergency arbitration decision from Japan Commercial Arbitration Association. And within 15 days, decision was rendered. Within 2 days, emergency arbitrator was appointed. So, the detailed procedures you will find, timelines and all you will find in the rules of different arbitration institutions. In fact, a couple of years back, I had done one emergency arbitration under the rules of Singapore International Arbitration Center. There also it was very fast. Now, question is, even ICC has provision for emergency arbitration, though they did not have this provision prior to 2012 rules, when ICC had substantially amended its rules. So, for any arbitration invoked after 2012, this provision for emergency arbitration was available. Now, sometimes you are faced with a dilemma. The dilemma is, should I approach the court or should I go for emergency arbitration? One has to take into consideration practical and tactical aspects for this particular, in order to take decision for this. There will be a lot of aspects which will be required to be weighed. For emergency arbitration, you need to pay some substantial amount of money. That is one thing. Emergency arbitration will be decided within 15 days approximately. So that is another thing. Now, let us assume that you want freezing order or attachment order against a particular property which is lying in India. Now you have arbitration agreement under which arbitration is seated in Singapore. So even if you obtain any order in Singapore, how will you enforce that order in India? Because emergency arbitrators' decisions are not award in that strict sense. These are interim orders, and that is one of the ongoing debate about the efficacy of interim measure through emergency arbitrators. So what will happen in that event? Even if you obtain the emergency arbitrator's decision in your favor, you may have to come back to India, initiate another proceeding under Section 9 and obtain an order. So in that event, your emergency arbitrator's decision is not going to help you. In fact, I'm in one Section 9 proceeding in Delhi High Court. I have argued during this vacation and in that situation, what had happened was there was emergency arbitrator's decision. But that decision was given in such a manner that was not really helping my client's position the way I wanted. So irrespective of that decision, I have filed Section 9 petition. And here, the other side took up the plea that how can you have a double bite at the cherry? How can you initiate a Section 9 proceeding through the court, obtain an order which you could have obtained, which could have been passed in your favor in that emergency arbitration, or it has not been passed exactly the way you wanted in that emergency arbitration. Now, question is, in India, position of law is that Indian courts do not recognize emergency arbitrator's decision. Whether emergency arbitrator's decision has gone in your favor or against you, independent of that, you can still file Section 9 proceeding. And in fact, there is a judgment of Delhi High Court in Raffles case, very detailed judgment running into around 103 paragraphs written by Lord Justice Bibu Bhakru. He says the courts in India will apply its mind independently whenever any Section 9 proceeding will be brought before courts. And this is what is happening in our case as well. So, Singapore has provision for enforcement of emergency arbitrators' decision. And you also have provision there for challenging that emergency arbitrator's decision. So if you are aggrieved with, somebody is saying which judgment? Raffles, R-A-F-F-L-E-S, Raffles. Now, somebody is asking time and again, force majeure clause in an arbitration agreement is neither here nor there. It has no relevance for this today's talk. So please let us not have irrelevant questions. If you have any such question, you can talk to me later after the talk. Now, in Singapore, as I said, emergency arbitrators' decisions are challengeable in court if one party is not satisfied. 1. 2, it is enforceable in courts if other party is not obeying the order. Now let us take example of Japan. I gave you an example of emergency arbitration in Japan, which I did. Now there is no provision for either enforcement of the emergency arbitrator's decision, or for challenging, making a challenge, bringing a challenge to the arbitrator's, emergency arbitrator's decision. So that is another anomaly there. But so far as India is concerned, in India, if you have, yes, there is one Bombay High Court judgment in which Bombay High Court said, obviously we cannot enforce your arbitrator's emergency arbitrator's decision obtained in another jurisdiction because it is not an award. However, you can rely upon that in your Section 9 petition. So you can rely upon that decision in your favor before the court, but court will ultimately decide for itself, applying its own independent mind, whether you are entitled for such a relief or not. So that is now we will go to next chapter of the talk. We dealt with emergency arbitration and the interim measure protections by the court. Now we will talk about the next stage in the process of arbitration. Now we talked about drafting of arbitration agreement. So agreement was drafted. Now next stage, so first stage was drafting of arbitration agreement. And now next step would be how arbitration is invoked, how arbitration process be set in motion. However, between these two stages, I talked about the interim measure of protection by the court because in between these two stages, you can go to court for the reasons we have just discussed. Now, how arbitration is invoked is the next thing we are going to talk about. Under Section 21 of your Arbitration and Conciliation Act, as per the Section 21, arbitration commences when notice of arbitration is issued by the party invoking the arbitration is received by the other side. So you want to invoke arbitration, you issue notice, and the day this notice is received by the other side, arbitration is deemed to have commenced. Though in practice, arbitration is not getting started that day, but this Section 21 has a purpose to achieve, and that is the day you issue the notice, the day notice is received by the other side, notice of arbitration, limitation period stops running. So limitation stops running. So that is the essential and prime purpose of Section 21 here. But at the same time, it also serves another purpose, that it intimates the other side that one party is now invoking arbitration. And one has to write a notice of arbitration. There you write who are you, who is other side, what is the dispute, what all reliefs you are seeking. Obviously, you can amend it later, but you have to give some framework so that disputes are identifiable, reliefs are in some way identifiable, the description of the case is understandable, description of the parties are understandable. So you write your notice of arbitration in this particular manner. Now somebody says, what is limitation period? Limitation period is basically, you may have a cause of action against somebody. Somebody may have broken the contract, somebody may have duped you, somebody may have done some wrong to you. or under the contract, a party has to do certain things which he is not doing. Now, you cannot say that I will pursue my remedy against that party after 100 years or after 50 years. So, in every country, in every jurisdiction, you have laws of limitation. Law of limitation says that if you have a particular category of relief you are seeking against, or particular category of cause of action you have against a party, you should bring your action or you should initiate your arbitration. In fact, Limitation Act applies to arbitration proceeding. So that's why we talk about limitation. So under Limitation Act, if somebody has broken the contract, somebody has not complied with the contractual requirements and so on and so forth, all those kind of events are mentioned in the Limitation Act. And Limitation Act says you should bring your action, you should go to court if you do not have arbitration agreement, or go to arbitration if you have arbitration agreement within a particular period of time. As a thumb rule, for most of the cases, not for all, for most of the cases, now there are certain situations where you can initiate your proceeding even after 12 years, within 12 years, but generally it is 3 years from the date when cause of action has arisen. Now somebody may ask, what is cause of action? Cause of action is when somebody has done something which gives rise to a right in your favor to go to court of law or get initiated an arbitration. That is called broadly cause of action. There was some problem, some technical issue at my end. Sorry for this interruption and inconvenience. But it is good that everybody got some breathing time to relax, because what we are talking today has got some amount of civil procedure code in it, some amount of technical aspects in it. So it may be becoming heavy for some of the participants. Okay, we will make it lighter now. We'll make it lighter now. So that is one thing, section 21 notice you write. Now, second issue is what happens when you have international arbitration agreement. So if you have domestic arbitration agreement, then you initiate the process by way of section 21 notice. But what if you have got international arbitration agreement? How do you go about it? Now, whenever you have international arbitration agreement and it is an institutional arbitration, in that event, every institution has provisions for request for arbitration. So request for arbitration provision you will find in every arbitration rule, institutional rule. And this again, under, let us take for example ICC rules. Under ICC rules, the day ICC headquarters at Paris receives the notice of the request for arbitration, no, it's charging now. request for arbitration, that is the day when arbitration is deemed to have commenced. Now, that is one aspect. Another aspect is what all to write in that request for arbitration. Every institutional rules have got provisions which tells you what all should be written, and what all should be written is something which I just discussed with you. You have to write about the description of the parties, you have to write about the arbitration clause, you have to identify the arbitration clause, you have to give brief description of the case, the remedy which you are seeking. So all of this. In fact, Article 4 of ICC rules talks about this. In fact, there is a very interesting debate and question. How much to write in your request for arbitration? Obviously, you have to write at least what is required under the rules. But then question is, should you set out a complete case? Should you bring out your complete case the way you do in your statement of claim, the main claim? Or you should be a bit economical? So question is, how much is too much? In fact, you have few proponents of the thought that you should come out with your best case, put your best foot forward. But you have people who say you should not disclose too much because you make the other side aware of all the nuances. So therefore, one should be a bit guarded. So my sense is, and my position on this is that you should be balanced in that. Take a midway. Don't write too much, but disclose your case in some detail so that at least case is understood well by the institution as well as by the arbitrators. Now, when you write this, when you issue this request for arbitration, when you issue this, it goes to the other side, and other side may other side will obviously reply to this, and invariably what happens is other side will challenge the jurisdiction itself. Not in every case, but in good number of cases, what you will find is other side will challenge the jurisdiction itself of the institution, or will raise various other jurisdictional issues, threshold issues. In fact, some year back, I was doing one arbitration. It was an ICC arbitration only. And in that case, other side raised that threshold issue that ICC has no jurisdiction to administer the arbitration because parties had not agreed for ICC arbitration. Somebody is saying, please share your contact number. You can, my contact number is 98101 63815. 98101 63815. However, you can get the numbers from the organizers. Rahul from Lex Area, he'll provide you my all details. Now let us come back to the point. Point I was discussing was that in that arbitration which I just referred to, the other side challenged the jurisdiction of the ICC, saying, I did not agree for ICC arbitration, therefore you have no jurisdiction, therefore you cannot refer the parties to arbitration, therefore you cannot appoint an arbitrator. Now under ICC rules, there is provision for threshold decision on its own jurisdiction. It is not a very detailed examination of the entire case of both the sides, but ICC court will just have a look at overview or prima facie view, ex facie view, whether ICC had jurisdiction or not. So ICC found to have jurisdiction in its favor. Thereafter, the ICC appointed the arbitrator, and before the arbitration tribunal, so that party had no option but to submit to the jurisdiction of the arbitrator, obviously with protest. And that party, a foreign party, raised the jurisdictional issue once again before the arbitration tribunal. Just because ICC said we have jurisdiction to send you, that does not mean that arbitral tribunal will not be having power to decide whether it has got jurisdiction or not. These are two different issues. So tribunal ultimately held a hearing, detailed hearings, and I had argued for one party in London, and ultimately that tribunal decided in my favor. So whenever you have request for arbitration, the other side will write whether there is a jurisdictional issues. There are multiple issues. One party may say that you have implemented two parties or three parties, but your contract is only, arbitration agreement is only with one party. So then what happens? You cannot implement party 2 and party 3. So that is again a jurisdictional issue. So there are multiple jurisdictional challenges which are made in different arbitration proceedings. Now, we will go to the next stage. So notice of arbitration, request for arbitration has been proceeded with. We have already talked about notice of arbitration or request for arbitration. So arbitration agreement was executed. Arbitration has been invoked by way of request for arbitration. Now next stage is constitution of the arbitration tribunal. Constitution of the arbitration tribunal. So constitution means how arbitral tribunal will be constituted. That is very important aspect. If you ask me, or if somebody asks me, what is the most crucial stage in any arbitration proceeding, ladies and gentlemen, I would say this is the most crucial stage. This is the most crucial decision which a party has to take or lawyer has to take, and that is who should be the arbitrator. That is the most important decision. In fact, I had said it on the first day itself, that there is a famous saying in the arbitration community that arbitration is only as good as the arbitrator. Though there is a sequel to it, and that is arbitration is only as good as the arbitrator, provided the respect of the lawyers and the parties towards the arbitrator. In other words, in fact, if arbitral tribunal is respected, arbitrating parties are conducting themselves well, in that event arbitration is as good as the arbitrator. So therefore, central role is played by the arbitration tribunal, means the arbitrator or arbitrators as the case may be. Now, first question is, now arbitration tribunal is to be constituted. Sometimes, obviously, it is the arbitration agreement which decides whether you will have sole arbitrator, means one arbitrator or three arbitrators. So that is the basically the source of this particular aspect. But I may discuss a bit about this aspect here also, and that is, should we have one arbitrator or three arbitrators? This is again a very this is an ongoing debate for ever, I would say, in the arbitration community, arbitration global community. There are proponents of the theory that we should not have three arbitrators. Now, biggest propounder of this theory, biggest advocate of this theory is Jan Paulsen, one of the biggest names in international arbitration world. He strongly believes that we should not have three arbitrators. And his rationale is, reasoning he gives is that in his experience and generally, party appointed nominee arbitrators, party appointed arbitrators favors the appointing party or favors the party which has appointed him or her. Therefore, Jan Paulsen says we should not have this. If both the nominee arbitrators, co-arbitrators are espousing the case of the nominee, of the party who has nominated them, if both the co-arbitrators are behaving like advocates for the party which has nominated them, in that event, ultimately, everything revolves around the chairman, the third arbitrator. So he has to decide ultimately which party is right, which party is wrong, who should get award and who should not. And if third arbitrator himself has to decide the case, then what is the need of having two more arbitrators and incur so much of expense, so much delay process? So that is his fundamental argument which Jan Paulsen quotes. But there are many, and there are good amount of support to this argument of Mr. Jan Paulsen. In fact, he has written about this in his very famous book on theory of arbitration also. If I'm not wrong, that is the name of that book, or philosophy of arbitration. Now, but at the same time, you have other school of thought which strongly believes, equally strong in believing, that we should have three arbitrators. So this school of thought says, first thing they say is that three heads are better than one head. In other words, three people will think better than one person. Another argument which is given, and which I subscribe to, this one which I am going to share with you, is that if it is a complex technical arbitration, in that generally what happens in that event, it will be a good mixture and good idea to have at least one technical person on the board, one technical person in the tribunal. And since it is arbitration, you must also have somebody who knows the law. So if you have a mix of technical person and legal person on the board, it gives completeness to the process. There is less reliance on technical experts who sometimes may or may not be biased. And again, technical experts are not always available to the tribunal for deliberation. Yes, in certain circumstances, tribunal even talk to them during the deliberation, obviously after disclosing it to the parties. But he cannot substitute the tribunal member. Tribunal member cannot be substituted. So I agree with this particular argument that we should have three if it is a technical. Obviously, you should have technical person, then it should be a mix. Another argument given is, and which I again subscribe to, is that if you have, see, in fact, the whole question is about the legitimacy of the process, legitimacy of the arbitration as a process. See, today, almost in 100% international commercial contract, you have arbitration provision and you have arbitration. And if you ask me one of the reasons why arbitration has become so popular, I would say that it is the confidence which parties have in the tribunal, because in the tribunal itself there will be one nominee of his in whom he has got all the confidence. So a disputing party gets confidence in the tribunal that yes, in this tribunal, one of the decision makers is of his own confidence. So my position will not be ignored. My position, my arguments, my submissions will ultimately get across to the tribunal properly. That is one of the duties of the tribunal members also. Duty is slightly a bit extreme word or tough word, but sometimes one asks a question: what are the obligations of the nominee arbitrators? Obviously, nominee arbitrator or the presiding arbitrator, they all are arbitrators. They all have to remain independent and impartial, despite of the fact that nominee arbitrators have been appointed by one of the parties. Just because you have been appointed by one of the parties, you should not assume that you are there in the tribunal just to serve the purpose of the party who has nominated you. In fact, there is very interesting thing. I'm just getting reminded of this. Till very recently, in USA, there were two sets of tests for determining the impartiality and independence of arbitrators. One set of test was with regard to the nominee arbitrators, and another set of tests were for the chairman or the sole arbitrator. So threshold was higher for the chairman or the sole arbitrator. But again, even in USA now, that dichotomy or that double test or double standards of test have been dispensed with. So there also now they all are equal. They all must pass through the same tests. So it is all about independence and impartiality. But one thing is that the nominee arbitrator should at least owe this much to the party who nominates, that if a particular aspect of that party's case is somehow missing the attention of the other arbitrators or the chairman, he should and he can bring this to the notice of that particular chairman. So that is perfectly valid and no issues with that. Now, another important aspect is, and we touched upon this a bit in earlier class also. If you have 3 arbitrators, then process becomes costlier because their travel expenses, their fees and everything. And it delays the process also, because now earlier you had, if you have 1 arbitrator, you have 1 diary to match with the 2 diaries of the lawyers about their availability of dates for the hearings. Now you will have 5 diaries which will have to get synchronized for getting the dates for the hearings and all. So that obviously delays the process. Another very interesting things which one come across is that sometimes, and this is real instance I am sharing with you, where the nominee arbitrators tries to derail the whole process, tries to frustrate the whole process, because the party which nominated him or her wants to delay or frustrate the process. Obviously, if the party or his lawyer or its lawyers tries to delay and frustrate, they can be sanctioned. They can be disciplined by the tribunal. But what if tribunal member, one of the tribunal members itself starts creating obstacles in the smooth functioning of the tribunal? So it becomes a big challenge. In fact, before I forget, I must tell you, one of the attributes which you should look at in the chairman or in the chairman is that he should be good in diplomacy. For more than one reasons, I'll go into that detail in a while. So he has to manage the tribunal, because one of the obligations of any arbitration tribunal is to see and ensure that arbitration gets completed and award is passed. If you ask me what are the duties and obligation of the arbitrators, apart from the obligation of being independent and impartial throughout the proceeding, next most important obligation is that you should render a good award, and you should render an enforceable award. Chairman is not supposed to succumb either on the pressure of the party which is trying to delay or frustrate the process, or he should not succumb to the pressure of one of the tribunal members. If he does succumb, it means he is not fit to be the chairman. That is why it is said in arbitration tribunal, the chairman should be very competent. He should be competent not only in terms of knowledge of law, in terms of knowledge of the arbitral processes and procedures, but he should be competent diplomat, because he has to deal with both the side lawyers, both the parties, both the co-arbitrators. So all these attributes that gentleman must have. In fact, one of the interesting attributes which I would say a chairman must possess is humility. Now, humility not in the sense that which we generally understand in normal parlance, but humility in terms of not thinking and presuming that the legal practices and cultures from which he comes is the best legal culture, because he has to deal with his co-arbitrators. He has to deal with two lawyers of two sides who may be from different culture. In fact, recently I started an international arbitration where all the three arbitrators are from the three different countries. Now, sometimes one may say that what if, so what? Three arbitrators are from three countries, but since all the three are from common law jurisdiction, let us assume that all of three are from common law culture. So what difference does it make? Ladies and gentlemen, it makes a lot of difference. Even if you are from the common law culture or civil law culture, in fact, in world you have 2/3 of population falls under civil law culture. Now let us assume that common law culture. Even within the common law legal system and legal culture, there are substantial variations in practices, procedures, and law. All the procedures and legal cultures in UK is not exactly the same which we follow in India. All the procedures and practices and cultures and law which one follows in Singapore is not exactly the same which we follow here. So there are, within a particular legal system, there are different cultures. So the cultural neutrality on the part of the presiding arbitrator and chairman is very, very important aspect. And you will realize the importance of this when you really face or conduct international arbitration where you have people from different countries. So these are very, very important aspects we must keep into account. In fact, sometimes party appointed nominees leak the information to the party which has appointed him, and that gives rise to multiple issues. The party getting to know about what is transpiring within the jurisdiction, within the tribunal, can come out with innovative ideas to frustrate the process. In fact, in a book written in the honor of Michael Snyder, one of the finest arbitrators from Europe, one arbitrator shared his experience that during the deliberation, one of the nominee arbitrators took a particular position and said certain things. Now, after deliberation got over, deliberation is a process in which the three arbitrators sit together to take decision for rendering the award. So what happened after the two nominee arbitrators left the chairman's office or the hotel room, the chairman, being a seasoned arbitrator, he was in the habit of disposing of and tearing off all the papers which were brought on the table during that day during the discussion, and he was in the habit of picking up papers from the dustbin and tearing it off. So what he did was, when everybody had left the room, he was just, picking up paper from the dustbin. There he found a paper which was a letterhead of the law firm which had appointed one of the arbitrators. And on the letterhead of that law firm's, that letterhead, somebody had written certain things, which was basically a letter or the communication from the lawyer of one party sent to this arbitrator, and this arbitrator said exactly what was written in that paper. So that casts doubt about impartiality of that particular arbitrator, and it is never liked. In fact, an arbitrator, co-arbitrator, who is good co-arbitrator, I would say. I don't know how to phrase this, or let me rephrase it. If a particular co-arbitrator from very beginning of the arbitration tries to behave like an advocate of the party which has nominated him or her, is never ever a good arbitrator, also for the reason that he will lose the confidence of the chairman. In fact, I know of cases, situations, and I have been privy to some of the such situations. I have been member of some tribunal where chairman will ask one of the co-arbitrators to write the award. Obviously, we will deal with this aspect. Who should write the award? How should deliberation take place? How award is finally drafted and prepared and all. We will deal with this later when we go to the aspect of deliberation and preparation of award. But today, I'll tell you that this is how it works. So therefore, in fact, there is one possible solution to this ongoing debate as to whether we should have one or three. Why can't one think of letting the arbitration tribunal decide and appoint all the three arbitrators? But again, this basically goes on the lines of the position taken by Ian Paulson. And it will not give confidence to the parties that we have got our people also sitting. Our people means person of my confidence. Confidence means that yes, I know of a person, I know of the competence of that person, I know of the impartiality of that person, but that person is there in the tribunal. So that is a very interesting aspect. So yes, that does not mean that in every case you should have three. For a small cases, as we discussed yesterday also, you should never have three arbitrators. It unnecessarily increases the cost. Yes, if you have three arbitrators, there is a flip side of this. And flip side of this is, while passing the award, more often than not, compromises do take place. What is that compromise I'm talking about? Compromise is that chairman gives some leeway to both side arbitrators. Let us assume that if chairman would have been all alone deciding a particular case, and he would have passed an award of, let us say, 50 million in favor of a party. But if he is sitting at a three-member tribunal, because of the pressure of the arbitrator who was the nominee of the potential award debtor, he may instead reduce it to $45 million. Now you may immediately ask this question, why should he agree to that? One of the fundamental aspects, one of the fundamental obligation, I would not say obligation, as I said, the challenge for any tribunal chairman is to pass a final award and enforceable award in the most efficient manner, in the shortest possible time. Now, in order to end, another important aspect is that chairman will always endeavor. Last month or something, I passed an award. We make, as a chairman, we make and we make all endeavors to pass a unanimous award, because if one of the arbitrators is not on the board, then it is a truncated award. Truncated award in the sense, so you have one dissenting award also. And endeavor within the tribunal, even within the courts, though in courts, the senior most judge has lots of say, and because of judicial discipline, you do not have bargaining. So therefore that example will not be appropriate. But in arbitration tribunal, all are equals. So therefore, in order to take everybody along, sometimes compromises do take place. And this is the flip side of three arbitrators. So that is one thing. So what is the time? 5:57. 6:57. So I think we have got now 6:57. We are 3 minutes away. So I think we should now close the session for today. Tomorrow I have many more interesting things to share with you, and I'll be very happy to share with you tomorrow and coming days. However, within these 3 minutes, 5 minutes, I can take some questions. So if I can see questions on my screen, I'll be ready to do that. Oh, somebody is asking, Shumit is asking about Perkins judgment. Perkins judgment is a judgment which says that party interested in the outcome of the arbitration cannot appoint arbitrator. So now this is the settled position in India now. Therefore, the governmental companies, public sectors who used to appoint arbitrators, either their officers used to sit as arbitrator or they used to appoint arbitrators. Now it is no longer possible. Yes, next question, if there is any. Okay, tomorrow I'll share with this, share the complete details of two judgments, the citation of Raffles and Bombay High Court judgment. So somebody asked this question. So any other question? Okay, so we will now, we'll meet tomorrow. My question of MSME, what is that? MSME has a tribunal. Under MSME Act, medium and a small scale. So you have a MSME Act, and which has got its own arbitration tribunal, permanent standing arbitration tribunal. So you have to go before that. Yes. Anything else? Whether jurisdictional disputes are decided by the arbitration tribunal or by the, this is Nikhil's question. Jurisdictional disputes, I have discussed. Jurisdictional disputes are decided by the arbitrators. If you talk about domestic arbitration or international arbitration, there are, I'll deal with that. I dealt with that, a bit of that today when I said that in ICC arbitration there is threshold issue. But ultimately jurisdictional issue in the domestic and international arbitrations are decided by the tribunal itself. Under section 16 of Arbitration and Conciliation Act, tribunal, tribunal is empowered to decide its own jurisdiction, and the famous doctrine of competence applies in India and as well as in other part of world. Yes. What happens when a judicial issue is decided in favor of the challenged? Challenge to, I cannot see the whole question, but if I get the sense of the question is, if jurisdictional challenge is made, and let us talk about section 16, you have made the challenge. If tribunal says that I have jurisdiction, then it cannot be challenged, appealed against, and matter has to go full length, and only after award is passed you can raise this particular jurisdictional issue. So with this, thank you very much everybody, and we'll meet tomorrow 5 o'clock. Thank you very much.
Thank you very much, sir.
Thank you, Rahul.
All the participants, I repeat, for e-certificates, you have to email us on the email ID lexadr.certificates@gmail.com. I repeat, lexadr.certificates@gmail.com. Thank you very much, sir. Thank you, everyone. We'll join again tomorrow at the